Welcome to the lecture for Psych 310. We're talking about legal and ethical issues related to mental health and abnormal behavior. We'll start off talking about civil commitment. First off, defining what it is. In a nutshell, it's a legal proceeding for hospitalizing a person with a mental disorder, or at least who is exhibiting some abnormal behavior. Now, the justification for the existence of such a process follows kind of two lines of reasoning. One, parens patriae, this idea that we need to protect disordered individuals or individuals exhibiting abnormal behavior. We have a responsibility to act, the country, the state, has a responsibility to act in place of the parents if parents aren't able to care for this person who can't care for themselves. So it's very much about taking care of individuals who might be in danger of harm. And the other justification for committing people, taking people out of the public and putting them in some sort of hospital-like facility is police power. And this is the obligation of the state, of the country, to protect society from individuals who may be dangerous to them. So it's both about protecting an individual from him or herself, but then also protecting society and others from harm that may come from that individual who's exhibiting abnormal behavior. So the criteria for civilly committing someone, for hospitalizing someone who's exhibiting abnormal behavior, one, they need to have mental illness, but mental illness as viewed by the courts. That's why I have here that it's a legal concept in this context. And for the courts, the mental illness generally is a severe emotional or thought disturbance that negatively affects an individual's health and safety and requires care. And the exact determination of what constitutes mental illness varies by state. Different states legislate different definitions. And usually at this level it excludes things like mental retardation and drug addiction, but it's very subjective, and it's not as simple as, oh, if you meet criteria for a DSM-4 diagnosis, you have mental illness. No, I mean you might meet criteria for major depressive disorder, but that doesn't necessarily rise to meet the requirement for having a mental illness in the eyes of the court. Similarly, you may not meet criteria for any DSM-4 diagnosis, but nevertheless you might meet criteria for mental illness in the eyes of the court. They're two separate things. But the court needs to rule, generally some judge needs to believe that you have emotional or cognitive disturbance that puts you at risk or puts others at risk, or that you can't take care of yourself. And then, so you have to have a mental illness, and then one of the following. Either the judge again rules that you're dangerous to yourself or others. And again, this is also a very subjective decision. How do you determine if someone is a danger to themselves or a danger to others, especially at risk? Like if you've already harmed yourself, we think, okay, well, the risk of you harming yourself again is high. If you haven't yet harmed yourself or someone else, it can be a little dicey in terms of determining what the risk level is. And from research, we know that the decisions that people make about who's dangerous and who isn't are frequently biased by kind of preconceived stereotypes. For example, in terms of who's more dangerous to themselves, homeless women stand out as a group that are frequently deemed to be at risk of harming themselves, more so than homeless men or other groups. And in terms of being a danger to others, black men stand out as a group that are given like kind of the same behavioral patterns as white men or black women. If you have this one characteristic being a black man, more frequently people will deem them as more dangerous. So there are these kind of biased decisions that are being made about dangerousness. And as clinicians, we kind of are aware that we're not very good at predicting whether an individual will be dangerous. We can say, if someone meets these certain characteristics, we give these tests, these assessments, and we gather data. If you have these characteristics, 60% of the people that have these characteristics will be dangerous, will commit a dangerous act. It means 40% won't, or even if it's 80%, still 20% won't. So we can't tell with a high level of certainty, generally, whether or not a person really is going to be dangerous, more dangerous than somebody else in the general population, or not. All we can do is make statements as to the statistical probability of risk. But again, it's not up to any kind of mental health provider to make that determination. They just make a recommendation, and then a judge makes the determination. So you have a mental illness and you're dangerous, or you're unable to take care of yourself. And it could be both, but at least one of those two criteria. And again, what's the set level for not being able to take care of yourself? Is it, oh, you can't pay your bills? Is it you can't drive? Is it you can't get a job? Is it you can't feed yourself? Well, depends on what state you're in and what judge you're in front of. But some determination of that, you have an inability to take care of yourself that's related to your mental illness. So, does this go down? What's the process? Well, there's two different ways. One, broadly, a voluntary civil commitment. And that's if somebody believes that they are a danger to themselves or another, and unable to take care of themselves, and that they have mental illness, they can ask to be committed to a facility. And generally there's an evaluation process, and usually if you have insurance, they will admit you. And typically, if you voluntarily commit yourself, you can leave voluntarily at any time, unless while you're there they determine that you're at increased risk of danger to yourself and unable to take care of yourself, and they might enact the process for an involuntary commitment. So people think, oh, if I commit myself, I can always leave. Usually, but not necessarily. You can leave unless they enact this other process and follow it through to the end to get you involuntarily committed. So for involuntary commitment, how can it go? Again, this kind of two paths. One, whenever there's not an emergency, so you don't have a gun to your head or anything like that, but just there's kind of been this pattern of behavior that's led to concern by others, and so generally somebody will petition the courts for involuntary commitment. Usually it's a family member, or maybe it might be the police. If they take you into custody, then they'll petition to have you committed, or it might even be a healthcare professional. If you end up in the ER due to erratic behavior, and the doctors there think you need to be committed to another facility, not in their hospital, but in some other hospital that's better equipped to deal with your particular illness or whatever difficulties you're having, they might enact the procedure. So that there's a petition made to the court, and then there's an evaluation that's conducted by some mental health professional. Could be psychiatrist, could be psychologist, could be social worker, could be counselor, depending on where you're at. But somebody's going to evaluate you in terms of the existence of mental illness, which again they'll make a recommendation for. Okay, I think they have this disorder, these problems, which wherever you're at, they meet the criteria for this or they don't, and also dangerous to self or others, and evaluating in terms of your ability to take care of yourself. There's a requirement that somebody that's going to be involuntarily committed, so I don't want to be committed, they have to be notified. Certainly you can't just grab them off the street. You can't just have the process, review some records, do your evaluation based on record review, and then lock them up. You have to notify them of the process. They have the right to an attorney to represent them in this legal proceeding. Excuse me. And then there are other variety of procedures, which we won't go into in detail, to prevent abuse of the system, because obviously if you're at all kind of Machiavellian, you could see the potential to abuse the system. Somebody you don't like, you're not getting along with, maybe a boss, and you petition to have them committed and try to get them locked away. If you have a friend who's a judge, maybe you can make it happen. And unfortunately, that kind of thing, there's a history of that in our country, and so there have been a series of procedures put in place to prevent the abuse of the procedure, and so that it should only be used really to protect people from themselves and to protect society, not for other motives. So non-emergency kind of takes this fairly drawn out process. In emergency cases, it's much more quick. And for emergency civil commitment, can be enacted by two people for brief periods of time: police officers, officers of the law, and physicians, not psychologists, not counselors, just only if you have a medical license, licensed by the state that you practice in. You have the authority, the power to involuntarily commit someone, hold someone against their will, that hasn't committed a crime, but is exhibiting aberrant behavior for a short period of time. And the amount of time differs according to state. Generally, it ranges from anywhere to 24-hour hold to up to 72 hours. And then after that brief period of time, then a judge gets involved, and you go through all the other stuff with the evaluation, notification, and the attorneys, and all that. But before that, if there's an emergency, somebody's got a gun to their head, gun to someone else's head, they seem actively suicidal or homicidal, police officers and doctors can hold them without having to go through all the procedures of having a judge sign something in order to protect that person or protect society at large. But again, after that short period of time, you have to go through all the other stuff to again prevent abuses of the process. Okay. So that's kind of where we're at now. And it hasn't always been that way. There have been a series of changes in how civil commitment's gone, and largely because, as I mentioned before, we have a history of abuses of the system. And in America, one of the early reasons for abusing the system was men who were having their wives locked up. If a wife found out her husband was cheating on her, and she might make a scandal, well, he could say, when she got upset about it, maybe she broke some of his stuff. He would say, well, clearly she's insane, she's breaking things in the house, I have no idea why, she needs to be locked up, and get his friend the judge to sign a piece of paper. In a way, she would go for an indeterminate amount of time. And other people, there are other reasons too, sometimes political reasons, that people were committed against their will by their political enemies. But again, the system was abused early on, and so there have been changes because of that. There's some early Supreme Court decisions that played a role in getting to where we are now. One of which would be O'Connor and Donaldson, 1975. It was about a young man who was committed by his parents. He was diagnosed with schizophrenia, and the superintendent of the facility that he was at then refused to release him for 15 years. And he wanted out. His parents wanted him out. They didn't think he was dangerous anymore, needed to be in there. In the case that went to court, they sued for damages and won. And the Supreme Court said that you can't detain someone who's non-dangerous and is able to survive outside by themselves or with help of others. So, and the superintendent said, well, he still has schizophrenia, he needs to stay here. And the parents said, yes, he has schizophrenia, but he's not going to hurt anybody, and we can care for him. He's not going to hurt anybody, he's not going to hurt himself, so you have to let him go. And the Supreme Court said, yeah, that's right. So why do you think the superintendent might not let him go? Why would he keep him there against his will? Well, unfortunately, one reason, I'm not saying it was the reason, but one reason might be financial. The kids being there, somebody's paying for that, either insurance or some state fund. So there's a profit motive in not letting people out of treatment. But it could also be that they think it's in the best interest of the patient. But unfortunately, in psychiatry and psychology, early on, again, we had some abuses, financial abuses, and making much more money than people should have been making for what they were doing. Another case, Addington versus Texas in '79. Frank Addington was committed after pushing by his mom, and he appealed the civil commitment, based on the argument that the standard of proof should have been beyond a reasonable doubt, right, which is what it is in criminal court. And originally he won, but then it was overturned. And in the end, the result of this whole process of the case was they raised the burden of proof of dangerousness for civil commitment from preponderance of evidence. That's what it was. But they didn't go to beyond a reasonable doubt. They said, but from beyond a preponderance of evidence, just meaning, well, a lot of people say you're dangerous, to clear and convincing evidence, which may not sound different, but the effect of that was it made it harder to commit people who weren't clearly dangerous. And that was the effect of really both of these cases. It became more difficult to commit someone and to keep them there for a long period of time, because too many people were being committed and based on little evidence, and they were being held for too long without justification for why they stayed there. And so these cases started to change that policy and said, okay, no, we're going to make it harder to put people in and harder to keep people there. Right? So the result of these changes, well, there were some perceived results and some actual results. One of the results was to some degree criminalization of mental illness. So some people who were exhibiting abnormal behavior, who probably had psychological disorders, they were no longer being committed civil commitment, right? So they're running out in the streets yelling, scaring people, and you can no longer follow the civil commitment procedure because they had tightened the rules. But they were still being kind of this kind of public nuisance, so they end up getting locked up in the local jails and prisons. So we have the result of that is a criminalization of abnormal behavior. Instead of putting them somewhere for treatment, so we made it harder to get them to those treatment facilities. They still can't be left alone and out in the public because people complain. They get locked up in jails. So that happened to some degree. So people not being committed ended up with increase in prisons to some degree, and then less of an actual result, but a really perceived result of these changes was, with fewer commitments and people not kept as long, and there's a general movement toward deinstitutionalization, which was a really significant movement in mental health treatment in America, initiatives largely instigated by Kennedy, where we took people out of the institutions because we were like, oh, okay, they're not getting good treatment in institutions. We need to get them back in their homes and in their communities and establish these community mental health centers, which is what MHMR was born from. So very admirable goals. Okay, we need people treated locally and not housed in these warehouses where they're not getting treatment. But so there was this mass exodus from institutions, and the perception was that when those people were booted out of institutions, that they didn't go to homes with families because they didn't have families, because we had the disintegration of family units in America, and instead they ended up on the streets, and we had this rise in homelessness. And there was a rise in homelessness, from the 60s on up through the 80s. But it's not clear that it was related to, as strongly related to deinstitutionalization as people thought. There are other kind of economic factors that also played a significant role. Was it 80? I can't remember what year. But in the 80s, they did a survey and found that only 25% of the homeless population had a previous hospitalization. So it wasn't like all these homeless people came out of institutions. Some did, but a lot of people were homeless for other reasons. Nonetheless, people thought that the increase in homelessness was due to this deinstitutionalization, people not being committed, and they thought, and to some extent it's true, that the increase in the prison populations was attributed to these the lack of people being committed and these kind of harsher rules. And so the pendulum swings back the other way, and now we change some of the rules so that it's easier to commit someone and keep them there a longer period of time. And it's probably beginning to shift back again. It will continue to go back and forth, and that's the way policy tends to go. But so far we've come from a place where you could commit anybody for anything for a long period of time, and then it got harder, and now it's gotten easier again, though less extreme. It's not as easy now to commit somebody and keep them locked up without a criminal trial as it was 100 years ago, but it's easier now than it was 30 years ago. Okay. And that's just for civil commitment. Again, you've not necessarily committed any crime or anything, you're just exhibiting some aberrant behavior, and people believe that you're a danger to yourself or others, and that you have a mental illness. So that's civil commitment. We also have criminal commitment. So now you've been accused of some crime. And criminal commitment is when you're held in custody, and one of two things is going on. One, you've been accused of a crime, but you're not yet fit to stand trial. Right? You haven't been found competent to stand trial. And we'll talk just in a minute about competence to stand trial. So that's one type of criminal commitment. So you're detained, and you're locked up. And that's a different procedure than the civil commitment. You've been accused of a crime. We'll talk about competence in a minute. You've been found not competent. We're not going to let you go, but we're going to hold you until the trial can take place. Or you've been found not guilty by reason of insanity of a crime. So you're not guilty, but we're not going to let you go either. You're going to be criminally committed. You committed a crime. You're not going to jail, but you're not going to be free either. You're going to be in a facility where you're monitored and have obviously restricted freedoms. Okay. Which brings us to a discussion of the insanity defense. So the not guilty by reason of insanity. And it's changed over time, what the rule is. And it started off, we have, back in 1843, the Monotone Rule, which established that you could be found not guilty of a crime if you had a disease of the mind that kept you from knowing right from wrong. And that held sway for a fairly long period of time. And in 1954, the Durham Rule changed how we saw it a little bit, and said that you had to prove to be not guilty by reason of insanity. You had to prove that the crime was a product of the mental disease or defect. And they dropped the not knowing right from wrong. So it doesn't matter if you knew right from wrong. All you have to prove is that you committed the crime because of your mental disease or mental defect. And those are the exact words. So if you have obsessive compulsive disorder, and you think if you don't shoot this person, then your mom is going to die. Right? That's your obsession. And you shoot that person and kill them, according to the Durham Rule, you could be found not guilty by reason of insanity, because the crime was the result of your obsession, which was a characteristic of your mental disease. And then we move forward in time again, from 54 to 1962, and the Alley Rule, the American Law Institute, said, well, if you could be found not guilty of reason of insanity if your crime was because of mental disease, because of mental disease, you don't know right from wrong, or can't control your own behavior because of that mental disease. So kind of expanded it a bit, and going back a ways to the Monotone Rule. So you have a mental disease, and because of that mental disease, you don't know right from wrong, or you knew right from wrong, but you couldn't control your behavior. So there was this compulsion that you knew it was wrong, but you couldn't stop yourself because of your mental disease. And then not a change from that, but kind of then there was an introduction of another idea in 1978. So this isn't a departure from the Alley Rule. The Alley Rule is still in place. And they added this idea of diminished capacity. And diminished capacity is about not guilty by reason of insanity, but that mental disease might negate criminal intent. So you're still guilty, and you're going to receive some punishment under the law, but if you have a mental disease, you might not have intended to kill the person. If you kill somebody but don't intend to, then it's no longer murder. Now it's manslaughter. So you might still be guilty, but of a lesser crime, because you had diminished capacity for understanding right from wrong, or what you're doing, or the potential impact. Like you shot them, but you didn't think they were going to die because you had some sort of magical belief that they were, invulnerable to harm. Right? So again, not replacing the Alley Rule, but just kind of offering this new idea of diminished capacity, which is still with us today. And then in after that, we have the Insanity Defense Reform Act, which, ironically, back to the beginning, right, back to the Monotone Rule, where what we have now is you're unable to discern right from wrong because of a mental disease, or mental retardation, which mental retardation probably captures the same thing that the journal was going for in terms of the mental defect, just in a different language. So because of a mental disease or mental retardation, you are unable to discern right from wrong at the time of committing the act. And that's still where we are for the most part in many states. Some states have started moving toward this a new concept. It's not all, but some, guilty but mentally ill, and this allows the legal system, to both treat and punish. So they say, you're guilty. Yes, you definitely did it, but you may not have known why you're doing it. So we're going to give you treatment, but we're also going to punish you. And it's not clear if this kind of guilty but mentally ill concept will stand up to the test of Supreme Court decisions. So stay tuned for that. So in terms of the use of the insanity defense, if you ask people, they think, well, yeah, it's used fairly frequently, maybe 20% of cases, maybe 25%. People think it's used quite a bit, and I think when it is used, it's successful. And they think that because that's what we see on TV. But in fact, it's very rarely used. People rarely plead, especially going before a judge to argue an insanity defense, and somebody saying, no, you're not insane. Rarely does it happen, and when it does go to court, they rarely win. Because usually, if somebody is clearly insane and wasn't capable of knowing right from wrong at the time of committing a crime, the prosecutor isn't going to take it to court because they know that there's this preponderance of evidence and clear evidence that the person was insane. So it doesn't go to trial often, and when it does, there's usually some question about whether or not they really are or were insane at the time of the crime, and so they don't win very often. One of the most well-known cases of the use of the insanity defense in recent history, recent local history, would be Andrea Yates, who killed her children and was arguably psychotic at the time. And in her first trial, she was convicted, and the jury, didn't think that she was insane. She pled, the insanity defense, but the jury at that time ruled that no, she knew right from wrong because of kind of the things she did in terms of planning the killings. But that was overturned. Oddly, I say oddly because of just the circumstances. There was a psychiatrist that had testified during the hearing about how there had been a TV episode of Law and Order that he had been an expert consultant for, that depicted a woman killing her children and then pleading the insanity defense and getting off, and that Andrea Yates had probably seen that, and that's where she got the idea. And that was a lie. There was no such episode, which really baffles me what the psychiatrist was doing. So that decision got overturned and thrown out because they said, there's this tainted evidence. We need a new jury. And the later jury disagreed completely with the first jury and said that she was not able to discern right from wrong at the time of the killings because of her psychosis. And so she was found not guilty of reason of insanity, but she's not obviously not walking free right now. Currently, I think she's in a state hospital in Kerrville, and will probably be there for some time. But one thing to note is to proceed through the litigation, the trials, she couldn't still be psychotic. Right? She has to be sane at the time of trial to proceed. Somebody had to determine her competent to stand trial. So if you are insane when you commit a crime, and that's kind of a permanent insanity, and again, insanity is this legal definition, but if you continue to have this kind of mental defect disease that prevents you from knowing right from wrong, you probably aren't ever going to be convicted. You won't be tried because you're not competent to stand trial. So you have to usually receive some treatment, medical, psychological treatment, to return you to sanity in order to be tried for what you did when you were insane. And that brings us to the discussion of competence to stand trial. So again, whenever anybody is exhibiting abnormal behavior, and there's a question of whether or not they can participate in legal proceedings in a competent manner, you need to do a couple of things to determine, in the eyes of the court, whether or not they can do that. And one of the major cases that shaped our current understanding of competence stand trial would be Dusky versus United States. And Dusky was actively schizophrenic at the time of the trial, actively hallucinating and had delusions. Sitting there in the courtroom interacting with his hallucinations, which he's probably not able to really do much to defend himself. And so, based on that case, the Supreme Court established kind of clarified the minimum requirements for establishing competence beyond just a mental status exam, which is what they originally used for Dusky. Oh, you passed this mental status exam, which is, where are you, who are you, what day is it? Answer those questions. Okay, you're competent. And the court said, no, that's too low a standard. Two main things. One, you must be able to understand the charges against you. So you have to be able to prove to the court that the person can understand what they're being charged with. Two, they must be able to assist or aid their lawyer or lawyers in preparing a defense. So they have to be able to communicate and understand, so they have to be able to express and receive communications from their legal team and preparing their defense. If not, then you can't have a trial. So you think, well, if you can't have a trial, do they just go free? No, you're held in custody. So innocent or guilty, we don't know yet, but you've been accused. If you're not competent to stand trial, then you're held in custody until the time at which you are competent to stand trial. At one point in time, it was you could be held in custody for quite a long time. And again, this is that one example of criminal commitment, right? So you've been accused of a crime, not convicted, but you're held in custody. That's a criminal commitment, which is different procedures than the civil commitment. It used to be you could do it forever. Now it can't be indefinite. And so how long can it be? Well, a reasonable time. What's a reasonable time? It depends on what the judge thinks is a reasonable time. But after some reasonable time, you've got to do one of three things. You have to find them competent and go to trial, and then determine guilt or innocence and deal with all that. Or set them free, which doesn't typically happen unless the charges are dropped or somebody else is arrested, that kind of thing. Or you move to a civil commitment procedure. So they're not competent to stand trial. It doesn't seem like they will ever be competent to stand trial, so they're civilly committed. So they're entered into a treatment facility, and you have to go through all the procedures of civil commitment. And then if they ever become competent after that, then they can come back and you can initiate the trial. But the usually thinking is, if that happens, they're not ever going to be competent. They have some sort of irreversible damage that will always prevent them from being able to stand trial. Okay, some other legal issues. A big one. The death penalty, which is a mental health kind of abnormal behavior issue. One, obviously, with the kind of insanity defense, because if you're not given a reason to insanity, you can't be executed. But the other big one would be related to determination of mental retardation. Right? Because in Atkins versus Virginia, they had to determine that it was there was at that time existed a consensus among the states that it constituted cruel and unusual punishment to execute someone who suffered from mental retardation, partly because of diminished capacity, they couldn't understand fully what they had done, and also it may not serve the purposes that the death penalty is supposed to serve. And kind of interesting side note about this case, Atkins had an IQ of 59. When he killed this guy, they tested an IQ 59, which is mild mental retardation. And then the appeals process go on, and then he was retested, and they said that because of the interaction with his lawyers, talking with lawyers and reading and doing other stuff while in custody, his IQ actually increased to 70, which was enough to then kill him. So it's like, yay, your IQ went up, but now we're going to kill you. But then there are some other things that went on. Eventually his sentence was commuted to life because of prosecutorial misconduct. So the prosecutors were cheating on some other stuff. And so we didn't end up getting to find out if your IQ raised while in custody, if they would still execute you. So it's unconstitutional to execute someone who is mentally retarded. But the Supreme Court stopped short of defining what mental retardation is. They didn't say, okay, if a psychologist, psychiatrist, physician diagnoses you with a DSM-4 diagnosis of mental retardation, which includes sub-average intellectual functioning, IQ below 70, and a pattern of impairment in functioning, social, occupational, academic, self-care. So it's not just IQ; it's this other stuff as well. But having that diagnosis isn't necessarily sufficient. What the Supreme Court did is said, well, we're going to leave it up to the states to define what is mental retardation. So obviously states that are more in favor of executing criminals have much more strict definitions of what mental retardation is. You have to be, the bar is a lot higher in Texas than in other states to be determine that you are mentally retarded, too mentally retarded to be executed. Okay, so health professionals playing a role there in determining whether people are going to live or die. Another legal issue, duty to warn, and this is for therapists. If a client tells you that they're going to harm someone else, so not just I'm really feeling angry and I want to hurt somebody, but my neighbors piss me off and I'm going to go home and shoot them. If it's kind of identified victim. I've been in a series of legal cases examining whether or not therapists can and should break confidentiality to warn those people. And the reason it's a bit of a controversy is because the client's right to confidentiality is essential to therapy. If clients don't think that whatever they say will be kept in strict confidence, then they're going to guard more carefully what they say. And so therapists fight for confidentiality rules, and generally the state, the government recognizes the importance excuse me, the importance of confidentiality for treatment, and the importance of treatment for the state in turn. But the most formative case related to this duty to warn would be the Tarasoff case, which maybe you've heard of in California a while back. There was a young man at a counseling center at a university that told his therapist about fantasizing about this woman that he had developed this kind of romantic delusions about, but she didn't in turn care for him, and he became less and less stable and indicated that he might hurt her. And the therapist actually did break confidentiality and notified the police, the campus police, and said, this student has threatened this student and I think he might harm her. Make sure he doesn't. And the campus police went to his apartment and interviewed him, and in all their expertise as campus police officers, they determined that he was not a risk to hurt this other person, despite this mental health professional's determination that he was a risk. And then he killed her. And the family sued the therapist and the university and the campus police and everybody. And so it went all the way to the California Supreme Court. And the California Supreme Court said that yes, there was a duty to warn, and that the therapist should have not just told the police, but should have warned the target, so that she could have had a chance to defend herself. So that's how it was defined in California. And in some other states, that Tarasoff ruling holds sway. In Texas, it absolutely does not. The Attorney General wrote an opinion clarifying how that would be applied in Texas, because again, the California Supreme Court isn't binding on Texas at all, and it wasn't a U.S. Supreme Court ruling. Eventually, there'll probably be some U.S. Supreme Court rulings that clarify across states what the rules might be. But in Texas, right now, there's not a duty to warn the victim. You do have a duty to warn, as that therapist did in California. You notify the police, the authorities. If someone identifies a clear target, you have a duty to break confidentiality and tell the police in order that they can stop the crime from happening. Why do you think it is that in Texas you wouldn't warn the victim? What might happen if you're seeing a client and they say, "Oh, I'm really so pissed at my dad, and he's been riding me so long, I'm tired of it, and I got my 12 gauge in the back of my truck. Screw it. I'm done with him messing with me. I'm out of here." And they get off and leave. You think, "Oh God, this person, I know they're fairly impulsive. I know they have this rock relationship with their dad. This person really might harm his dad." If you call the dad and say, or maybe let's say, make one more. Say it's a stepdad, not the dad. You call the stepdad and say, "Your stepson's coming, and he said he's going to shoot you. Get out of the house." What might happen in the state of Texas? Well, the stepdad might say, "Get out of the house, hell, I'll be ready for him." Kid knocks the door, opens the door, stepdad blows his head off. Was the stepson gonna shoot the dad? Maybe, maybe not. But he sure is dead. So given the degree to which we are armed as a populace, it doesn't make sense to tell somebody that somebody's coming to kill them. It makes more sense to tell the authorities so they can intervene and prevent anybody from harming anybody else. So the Terrasaw ruling applies in California and some other states, but not in Texas. There's a duty to warn, but it's not warn the target, it's warn authorities. Duty to notify might be a better term for it. Other legal issues, mental health experts might be called on to testify as expert witnesses related to abnormal behavior. And if you're an expert witness, you obviously have to be an expert in something. Being a licensed therapist or psychologist isn't sufficient to be an expert in the eyes of the court. This is whenever you have above average knowledge in some specified field, and you're testifying about your knowledge in that field, about your knowledge of postpartum depression, or your knowledge of PTSD, or your knowledge of family dynamics. More rare. But when you do that, that's different from being a fact witness, right? A fact witness is whenever you're testifying about something you've seen or heard. So maybe you have a client that shot somebody. You might be called as a fact witness about what they told you in the course of sessions, or about how many times you saw them as a therapist, that sort of thing. And we'll talk in a minute about clients' right to confidentiality. But for now, know that you might be called as a fact witness to testify about some things you know about them. But that's different from an expert witness. And if you have a client that is involved in a crime, you might be called as a fact witness, but you cannot be called as an expert witness in that case, because that would involve taking on more than one role. So you have the role of therapist or evaluator or assessor or whatever, and then the role of expert witness, and those are two roles that can't overlap. So you can't be an expert witness case in a child custody case where one of the parents was your client, and that's not legally prohibited, but it's ethically prohibited by professional organizations, which counselors are members, and also typically by the state licensing boards where counselors get their licenses. So you can be a fact witness, and you can be an expert witness, but you can't be an expert witness with your own client, current or previous client. Things that you might be asked to be an expert witness about: predicting dangerousness. So if you're an expert at predicting, if somebody is going to harm others, or you might be an expert in predicting suicidal, self-mutilating behavior, you might be called to testify about that, and so you would review the files, the case notes from other people, and then say, based on my expertise, this person matches the profile of somebody who would hurt themselves, or this person does not match the profile of somebody that would hurt themselves. And as a profession, we're fairly good at predicting dangerousness over the short term. So within the next 2 days, up to maybe 3 weeks, we do a fairly good job of predicting if somebody's dangerous. Beyond that, so is this person likely to hurt someone else 6 months from now? We don't know. People change too much. So short term, we can predict pretty good. After that, the accuracy drops off. Another thing you might be asked to testify about would be whether or not someone is malingering, right? And malingering is when somebody is faking some problem, either a psychological disorder, maybe a physical disorder. If you're testifying as a mental health expert, it would be obviously about a psychological disorder. So if somebody is faking psychosis in order to plead insanity or to plead to seek this kind of ruling on diminished capacity, you might be called on to say no, they're faking, because if they really had psychosis, they wouldn't answer this question in this way. Because I'm an expert now, I know exactly what psychosis looks like. Okay, so those are some other legal issues. Now we'll talk about a broad set of legal issues, the rights of patients and clients. One, they generally have a right to treatment, and there are minimum standards of treatment. And in the U.S., that's largely related to a decision, Wyatt versus Stickney, which was a class action suit that was brought about because of conditions at a set of mental health facilities where they were really just trying to make patients more manageable and not really treating them. So kind of like back in the old days in the old asylums where chained to the walls. It wasn't that severe, but active treatment wasn't a goal. It was, let's keep these people manageable because they can't be let out of society, they can't be put in prisons, but we want to make our jobs easier. What can we do to do that? So there was a big lawsuit, and the court set out that you have to have certain minimum standards that must be met for treatment. And the court doesn't say here are the minimum standards, but they kind of say there must be minimum standards among the profession, and you leave it up to the profession and the professional organizations to determine what those minimum standards are. But whatever the profession agrees, this is the least you have to do. They have to do at least that. And then the other thing is, in terms of treatments, you always must use the least restrictive alternative. So if someone is being unmanageable, and maybe they're having a problem with their roommate in this facility, and you can either put them in a room by themselves, or you could give them high doses of Thorazine to where they sit quietly. The Thorazine is more restrictive because it restricts all behavior. So you have to, if you can, you do the least restrictive alternative. You let them have a room by themselves. Right? You don't chain them up. You do something else. So the least restrictive alternative standard was put in place at that time as well. So people that are receiving mental health care must receive minimum standards, and you have to use the least restrictive alternative. Right? And it's aimed at preventing abuses and making sure that healthcare facilities aren't just prisons, as they tend to become sometimes. Also, patients have the right to refuse treatment. And usually, obviously, whenever you're out in the public, that's a no-brainer. Yeah, if you don't go to the doctor, you don't have to get treated. But the right to refuse treatment really comes into play when people are in custody, right? So, been committed civilly, criminally, or imprisoned. And this came up with a case that was Riggins versus Nevada, where he actually had been psychotic, and they had forced him to take antipsychotics, so he's no longer psychotic. But he wanted to be able to not take his drugs before going to trial, so that the jury could see what his psychosis looked like, so they would understand why he did what he did. Which the court didn't really consider that line of reasoning in terms of can you refuse drugs in order to look psychotic. They didn't even consider that, but they did say you can't force drugs unless two conditions occur. One, you can force drugs, or you can force some treatment if it's the least restrictive alternative. So in a least restrictive alternative, in order to do something. So in Regan's case, he had to be competent to stand trial. So the state has a vested interest in you being competent to stand trial. So they can enact some treatment in order to make you competent, so you can stand trial to figure out if you're guilty or innocent. I mean, you can't just refuse all treatment so that you never go to trial, so you can stay in a mental health facility. They can make you become competent, but they have to use the least restrictive alternative. So if they could reduce his psychotic symptoms enough that he could participate in the trial, understand the charges against him, communicate with his lawyers. If they could do that without the drugs, then they have to do it without the drugs. If they can't do it without the drugs, then it's okay to use the drugs. So you have to use the least restrictive alternative in order to ensure competence, or in order to promote the safety of the individual. So if he's going to kill himself without some treatment, you can force some treatment in order to keep them from killing themselves, but it has to be, again, the least restrictive alternative in order to keep them safe. So keep them safe and make them competent, and then it also must be medically appropriate. And this gets very tricky in terms of proving which treatments are medically appropriate. And this goes back to reviewing empirical evidence about whether or not certain drugs are effective in treating certain symptoms and/or conditions. Okay. So we talk about the rights of patients and clients, but also related to the abnormal psychology and the study of abnormal psychology in terms of one of the two other points I wanted to cover on that. Jumping a bit. Privileged communication. I kind of said I would come to this when talking about being a witness. You may be called upon to testify against your client. Licensed therapists, you're licensed by the state. Anything that your client says to you is privileged communication, and the client is the holder of the privilege. That means that you can't tell anybody what they told you unless they sign something saying that yes, you can disclose this. Now there's some exceptions to that. If you determine that they're at risk to harm themselves or someone else, you can tell other people, hey, they're going to kill themselves, stop them. And then if they tell you that they are abusing a minor, a disabled person, or an older adult, then you are allowed and required to break confidentiality and notify the appropriate authorities about that to prevent vulnerable individuals from continued harm. And then the last one is if they sue you, right? If they sue you for malpractice or whatever, then you're obviously allowed to defend yourself and use what they told you in session in the context of defending yourself and indicating, proving that you provided competent care. Beyond that, if they say, I killed someone 5 years ago, no, you can't tell anybody that. That's privileged communication. Unless I killed someone 5 years ago. Was this 14-year-old kid that was living with me? Are you living with another? And you have any children living with you now? Yeah, I've got a 14-year-old kid living with me. And he's really pissing me off. Okay, now that might constitute risk to a minor, and now we can possibly break confidentiality. It becomes a little grayer depending on what other information you know. But generally, kind of past crimes, you can't share. Now, a judge can send you a subpoena. And if a lawyer sends you a subpoena, you respond to it. Yes, I got your subpoena, but you don't have to give them anything. If a judge subpoenas your records, then it gets a little trickier. Generally, you're allowed to say, yes, I saw them, and I saw them this many times. But beyond that, if the person doesn't waive their right to confidentiality, a judge won't ask you for what was said in session. And if they do, then it could obviously go to a higher court. And you find out if exactly where the state currently stands on the rights of clients. But generally, everything is protected unless the person waives that right. Okay. Another thing that patients and clients don't have a right to is ethical treatment. So it kind of goes back to the minimum standards. Ethical treatment is defined in a lot of ways. There's a lot of different ethical standards for different professionals. And they're enforced two ways. One, by professional organizations. So like if you're a psychologist, the American Psychological Association, APA. If you're a counselor, the American Counseling Association. If you're a member of that organization, they have an ethical code, and if you violate it, then they can do certain things to you, usually fine you, kick you out of the organization. And then there's also, if you're practicing as a professional mental health care provider, you're licensed by whatever state you practice in, and that state usually has some of the ethical code built into their laws regarding providing care and regarding your license. And so they can fine you, take away your license, and certain ethical violations have been criminalized in certain states. So sleeping with a client, if you take advantage of a client and have sex with them, and the state can prove that you manipulated them using your power to do so, that's not only an ethical violation, that's a criminal act, and you can be prosecuted as such. So there are lots of ways that clients and patients are protected by ethical codes and legal codes. Okay, now moving on to rights of research participants. A couple things. One, they have a right to informed consent. So they have a right to know what they're getting into. So how long it's going to take for their participation, what the risks are, what the benefits are. So if you're going to have them submerge their hand in ice cold water, you know, this is an experiment on pain, so you will experience some painful stimuli, which won't leave any lasting nerve damage, but will cause you blah blah blah. So you tell them what they're getting into as much as you can, and so there's kind of two things here. One, you don't want to tell them exactly what you're doing because it might influence how they behave and screw up your study, but you have to tell them enough that they can be reasonably informed whether or not they want to participate or not. And usually that involves telling them risks and benefits and length of time, not necessarily telling them exactly what your hypothesis is. They don't have to be informed of that. They have a right to privacy, so their participation should be kept private, and depending on how you do it, you might have their data might be anonymous. Generally it's not anonymous, generally it's confidential, to where somewhere along the line there's a match between their identity and their answers, but that information is disconnected at some point, to where when other people are analyzing the data, they don't know who said what. But at some point usually you have an informed consent form that has a case number that matches the actual data. But that you don't go telling people about what somebody said or did during an experiment, and that's kind of an ethical obligation on the part of researchers to maintain that privacy. They have a right to be protected from harm. There's an obligation from researchers to make sure that bad things don't happen to people, and if bad things do, you have a responsibility to do something about it. So if you do a study where you have people talk about painful memories from childhood, you have to be aware that that could cause some harm, and you must provide them with counseling, debriefing, something to help address any kind of harm that you may have caused. And last, they have a right to quit at any time. So if for whatever reason they have to have the autonomy to decide that they want to stop participating in your study. Okay, so some of the rights of research participants. Summing up all the stuff we've talked about here, about the law and ethics. Generally, mental health professionals don't determine or enforce the law. Right? We have judges and lawyers and police officers that have that role. But mental health professionals do play a large role in many legal proceedings because of their expert knowledge of human behavior. So it's important to be aware of that interplay and the potential impact of the research that's done on human behavior on all these other legal proceedings and on this kind of life and death decisions about people, and whether somebody will be imprisoned for the rest of their natural life or allowed to go free. And many times that can hinge on something that's related to some phenomenon that's discovered or explored in researching abnormal behavior. So an important connection between the two in some ways. Okay. That's it for now. Take care.